Call to order the meeting of the special meeting of the Glendale Successor Agency for the date of May the 30th. Roll call, please.
Board members Apkarian, Anzafame,
Here.
Nakasone,
Here.
Ochoa,
Here.
Sheehan,
Here.
Steger,
Here.
Chair Raggio.
Here. And the report of the city clerk.
The agenda for the May 30th, 2012 regular meeting of the Glendale Oversight Board was posted on Friday, May 25th, 2012 on the bulletin board outside Glendale City Hall.
Thank you. May I have an approval of the minutes or additions or deletions?
So moved to approve.
Second.
Any additions or deletions? Seeing none. Roll call.
Board members Apkarian, Lanzafame,
Aye.
Nakasone,
Yes.
Ochoa,
Yes.
Sheehan,
Yes.
Steger,
Yes.
Chair Raggio.
Yes. And now we'll go on to item 3, which is informational items.
Is update on DOF approval of ROPS.
Thank you. Good afternoon, board members. I would like to hand out a handout that I just printed from the Department of Finance's website. Oh, just for the record, I'm Elena Boboyan, staff support to the Oversight Board. What I'm handing out to you is a letter that we received from the Department of Finance yesterday indicating their approval of our ROPS for both ROPS 1 and ROPS 2, with the exception of 2 items, which is the city agency loan and also the 20% housing set-aside items. The letter tells us to check the Department of Finance's website in order to find out what amounts we will be allocated in the Redevelopment Property Tax Trust Fund for each ROPS period. As of 2 p.m., our agency's numbers have yet to be populated by DOF. I know DOF's been working overtime to try to populate all of the fields for the 400-plus agencies statewide. So as of 2 o'clock today, we still do not know what our amounts will be for either ROPS 1 or ROPS 2. We will continue to monitor the website, and as soon as those numbers are out, we will notify the board. But as of right now, that's the update, and if you have any questions, I'd be happy to take them.
And again, what were the items that were not approved?
The loan with the city and also the 20% set aside for housing.
Is the housing relevant because we took action last time that the successor agency was responsible for housing? Is that relevant to what we do?
It's a little bit different. The action you took was to assume to confirm that the housing authority can accept the housing functions that were previously transferred. This 20% housing set aside, it's our contention that that part of the law was not repealed, so we still have that obligation to do that. And so that's why we listed it on our ROPS.
Time in the future as to what their decision is.
Well, their decision is that it's not allowed on the ROPS, and so their approval letter is minus those 2 items.
But is there a dispute resolution process, format, something coming? So it lies there fallow.
The letter says if we have any objections to their letter, we need to contact the Department of Finance.
But what about if a housing advocate decides to sue us? We generally get somebody at the Glendale Housing Authority that is actually in this last meeting yesterday threatened litigation because we're not complying with housing statutes under state and federal law. But how do we address those types of complaints that we think that 26 didn't knock out housing? DOF is saying it did knock out housing, but either way we still have the housing obligations without any way of fulfilling the obligation.
I'll ask Jillian Van Meiden, our legal counsel, to answer that.
Absolutely.
members of the Oversight Board, Member Choa. It's a complicated issue. What we do know is that AB 26 did not repeal the requirement for the 20% set aside. What we do know is that a judgment is an enforceable obligation. So in an odd way, if there were a housing advocate that sued and was successful in forcing the agency to undertake its affordable housing obligations using set-aside, that would in fact be an enforceable obligation pursuant to AB 26. But right now, the state of the law is somewhat in flux. I will be, in a few moments, making a presentation on the May revise, and that is an attempt to synthesize some of the recommended changes of AB 1585 and other changes to AB 26 that are supposed to address not only housing issues but other issues. But at this moment in time, we are certainly open to being sued by a housing advocate for failure to fulfill our obligations that are otherwise set forth under community redevelopment law, and that is a great concern. I might also add that there was a lawsuit filed out of San Diego to force seeking declaratory relief of the housing obligations that are still remain within the community redevelopment law, and I don't have the current status of that suit, but I'd be more than happy to provide that information to the members because it is an open issue and we are concerned about it, and it's certainly a possibility that we could be sued.
So you'll keep us informed.
We will do our best in that regard, and on that specific issue, I will give you an update on that piece of litigation.
And just kind of a general question, if I can, Mr. Chair. Mm-hmm. Are we happy or not happy about the approval of the ROPS?
We don't know. We don't know because the numbers are the key piece of information for us.
But based on the letter that you got,
we're not happy.
why?
Because we feel the Glendale residents and the Glendale taxpayers who years ago fronted the agency funds, as we call it, the city agency loan, have to write that off now because of DOF, versus bondholders whose obligations are recognized by DOF. So our community is at a disadvantage.
Would it be safe, though, to characterize this as some good news with a little bad news in it? I mean, I know that the loan is certainly important, but it sounds like they're approving some of the projects and obligations that we have that would provide some betterment to our community.
I agree with that.
So at this point, is it safe to say that if it's not coming from property tax revenues, they're going to allow any of the projects or all of the projects by virtue of them approving every item that was on the ROPS, save those two, are the other projects that were listed, the Disney project, some of the other projects, as long as they aren't being taken from property tax revenues, they are now projects in good standing that will always be funded until their completion?
We tried to get clarification from DOF in that regard, and basically every 6 months they get to review our ROPS, and any funding that's requested from the trust fund is going to get more scrutiny. To the extent we list other sources of funding, the DOF doesn't really care about that, but they will scrutinize. So if they approved something on ROPS 1 or 2, and at a future time, when it comes time for ROPS 3, they can still disqualify it. So just because they approved it on one ROPS does not mean that it's forever deemed approved by DOF.
So when we approved those ROPS and kind of went through them point by point in great detail last time, there were a number of items that didn't have a dollar amount, or at least a very small dollar amount, because at this stage in the project they hadn't incurred a great deal of cost. Are you saying that as those projects mature and the costs become greater because we move from architectural design to construction, that then the Department of Finance may very well disallow those projects?
Yeah, and actually they confirmed that in their letter on page 2, the first
why
paragraph.
Why would they allow us to spend the pre-development monies? Just to keep architects, engineers, lawyers in business, or?
It's very frustrating because the third parties are looking to us for final resolution, and we can't provide them with that.
I'm sure that many other cities have this same kind of a problem. What do we do about it? Because it's something that can't go on and on and on. In one way or another, it has to come to a settlement and says, all right, we have consistent rules that we can live by, and all of us will have the same rules. But when you're playing catch-up on this, and then you find out that you made a commitment and you go downstream and then it's pulled back, the end result is another loss. So what is our alternative, other than just simply saying that it's difficult to live with and that? I'd like a different kind of an answer.
I may be able to address that in my portion of the,
Okay.
on the update in the litigation, which will include, as I mentioned, a review of the amendments to the May revise, and also some additional information that the League of California Cities working group has been working on for purposes of answering the very questions that you have.
Ron?
There was supposed to be an audit that was going to be done by the county. Would that audit shed some light on what projects are going to be able to move forward or not?
The timing of the audit was very funny because we were in the middle of we were the first agency in LA County to be audited, and the audit has been wrapped up. It's our understanding that it's in internal review by the company that was hired to audit us, and we have yet to see a draft version. That audit is supposed to do two things. One, make sure that any items we listed on our schedules, trace back payments that we've made back to our schedules, and also look at the underlying agreements to determine if we actually do have an obligation or not. So DOF's timing and distribution of these funds and us not receiving our certified ROPS, I don't know how to answer that. I'm not sure.
That provision is being eliminated from the May revise. I'm sorry.
Just to follow up, that was a very good question by Mr. Nakasone. So the audit's not done, but they've approved the items that the audit was supposed to audit.
In a way.
Okay.
Chair Raggio, if I might add to further, I don't want to say create confusion, because there certainly is a lot of confusion relative to the implementation of AB 26, but in the most recent version of the May revise, the requirement that there be a certified audit of the ROPS prior to approval by the Oversight Board, there's a proposal to eliminate that provision.
How does that help us?
Well, if I could ask a different question that might help. We've already approved it, so we're already running behind anyway. So that kind of doesn't matter.
But it may help on the next ROPS we have.
I hope so.
Yeah.
I certainly hope so.
And the timing, the May revise also extends the time from July 1st, I believe, to October, which shows that the counties are probably behind in getting these audits done.
Thank you. I don't know whether thanks are in order, but thank you. The next item is you're going to bring us up to date on
Yes, thank
any
you.
legislation.
That would be item 3B on the agenda, an informational item. On May 18th, the Department of Finance issued again, my name is Jillian Van Meiden, and I'm General Counsel for the Community Development Department, City of Glendale. On May 18th, the Department of Finance issued a May revision, Redevelopment Agency's Dissolution, Cleanup, and Liquid Assets Provisions. I provided in your packet a summary that was completed by the League of California Cities of that May revise, and just some of the highlights to the initial revise were concerning transfer of assets to the taxing entities, It clarified that successor agencies were to complete their review of low and moderate income housing fund assets, what was unencumbered, by October 1st, and of all other unencumbered funds by December 15th for transfer to the auditor controller and then further to the taxing entities. It added clawback of cash transfers such that the DOF controller and
Is clawback a technical term?
Well, it's not. It's becoming a technical term with respect to the functioning of AB 26, in that it would be a transfer back or a clawback of monies that were allegedly transferred illegally or in violation of AB 26 from agencies to cities. So first there would be a threshold determination of whether or not there was a transfer in violation of AB 26, and to the extent that that was determined, then those monies would be pulled back or be required to be transferred back to the agency for distribution or dissolution, distribution, sale. That would include property assets as well as liquid assets and financial assets.
So we can anticipate seeing this term frequently then?
I would think so, yes. So the clawback of cash transfers, DOF controller and county auditor controller can require the return of cash and other funds, quote unquote, improperly transferred from redevelopment agencies or successor agencies to other public entities or to private entities. Property tax and sales tax offsets would be authorized if the public entity it fails to return the funds. So there is a penalty provision that was included in the initial version of the May revise. Third, housing assets. New definition of housing assets is recommended, to include rents, loans, repayments, and other payments from developers that could be used by housing authorities to continue to perform their functions as required. However, the Oversight Board would be required to approve the transfer of housing assets to a successor entity, should that be necessary. And then there had been questions about mixed-use assets. As we know, many housing projects include not just residential components, but also commercial components and other components. And there needed to be clarification. So that piece was included in the May revise, such that the Oversight Board could review whether or not all or part of that asset should be divided up. In some cases, it wouldn't make sense to divide up, so an alternative form of disposition would be necessary for those mixed-use assets, and that was recognized. Fourth, it talked about increasing successor agency flexibility in some regard, and that included Polanco Act immunity would be transferred to the successor agency. In a nutshell, the Polanco Act gives special powers to former redevelopment agencies for purposes of cleaning up contaminated properties. And so there's been quite a large effort in the background in order to ensure that some of those efforts could continue and the liabilities and immunities, particularly the immunities, would flow to the successor agency, and permissions would be included to allow them to complete those cleanup. Additional increased flexibility would include the ability to refund or refinance bonds with oversight approval. So there was some loosening of AB 26 in that regard. The ability to enter into contracts to spend the bond proceeds with oversight board approvals. This has been a large stumbling block for many cities throughout the state, where in one instance, well, AB 26 expressly states that bond proceeds should be used for the purposes for which they were sold. But then on the other hand, there are other provisions that were restricting the ability of agencies to enter into contracts in that regard. And so efforts have been made beginning with and including AB 1585, but now flowing into the May revised language that would help agencies who have made, in some instances, pre-commitments, which we have with our bond proceeds, but also where those bond documents expressly call out specific projects and they were sold for the purposes of using those proceeds for those projects. So this, we're still in the sausage-making process when it comes to getting final language concerning the bond proceeds, but at least there's recognition within the May revised language that proceeds from bonds need to be treated with a little bit more carefully and respect to the obligations that were set forth in the covenants and in the disclosures. Also included in successor agency flexibility is the ability of the city to loan money to the successor agency with oversight board approval, and then to be paid back through property tax allocations on the ROPS. So a new listed obligation on the ROPS. More to come on that as to what limitations there may be with respect to what that loan would entail or what it might be limited by. But that is a new level of flexibility which will help successor agencies be able to function, whether it's vis-a-vis loans received from the city for that purpose. Another area of change was increased authority of the Department of Finance and the Auditor Controller. Interestingly, one of those provisions would allow the Auditor Controller to deduct from property taxes deposited into the trust fund on behalf of the successor agency for the July to December period an amount equal to property taxes that weren't transferred to the taxing entities on October of 2011. Now remember, the Matasanos case stayed the activities of both the redevelopment agencies and the Department of Finance and the state until the matter could be heard on its merits and a decision was issued. The upshot of that was that property tax distributions weren't made, and this is an effort to take that distribution that wasn't made at that time in the fall or in May during the May distribution. The successor agencies and the taxing entities didn't receive a May distribution either, but this make-up provision would take that payment from monies that would have otherwise been paid to the successor agency. There's been a tremendous response to this particular provision, but this is the first version of the May revise. I'm giving you what the proposed amendments were. If there were some questions, I'll stop and answer.
From what you just said, though, the result of that is taking that money from May. Is successor agencies come up short and don't have any way to make their payments on the obligations, even if they're recognized obligations, the money's not being distributed? Did I get that right? That's
it. This is not a very appropriate amendment. As I said, there's tremendous pushback on this particular amendment, but it is what was proposed in the May revise. There's been a lot of reaction.
You have to keep in mind these are proposed.
These are proposed.
They haven't been acted on.
They have not been acted on, but there is an effort. In fact, today, on the third version, which I will try to get to very quickly, the responses from League and other individuals that are reviewing the ROPS, are reviewing the May revise now, were expected in by 2 o'clock today, so that this could be finalized in some form. They want to vote on it so that they have a budget bill by June 15th. So there is tremendous heat under this process to complete it, and a lot of effort.
One of the questions I have on Exhibit 1 is item 2, and it's entitled "Empowers DOF with Final Decision-Making Authority." And what it says in here, in so many words, is that the authority of the Oversight Committee is somewhat subject to the DOF in all cases. Is that true?
That is definitely true within the first version of the May revise. However, as we flow forward to the most recent proposed amendments to the May revise, and maybe what I should just do is finish with what the proposed amendments were and then jump right to where we're at right now in terms of where the language seems to be going, so that we've got a sort of it's lengthy, it's somewhat complicated, but I think it's worth the effort to understand, because where we're going is from what you just stated, and that is less control or less authority of the Oversight Board, more control flowing up to the DOF, to the current version of the May revise, which is hold your horses.
But what assurance does a successor agency have that the DOF is able to cope with this kind of thing?
None.
That you got 400 agencies all making the same appeal at the same time. How do they react to it?
Well, the current reaction...
And are they staffed to?
That's a good question, a question that I can't answer. I can only speak to what Ms. Babolian and I experienced, and that is that we know that we were one of the agencies that was a little further behind than some of the others, and that after we initially submitted our ROPS and commenced the iterative process of answering their questions and providing documentations. I believe it was 2 Fridays ago, we received a letter from them stating that we had 3 hours to approve their revisions. So the sense that I got from that response is they are understaffed, unable to fulfill the requirements of AB 26, and that is quite simply to make a determination of whether or not those items listed fall within the definition of an enforceable obligation.
But isn't it, when you look at the issue of the state being able to deduct from future allocations of property tax that which they deem is theirs on a prospective basis, it's a bit like double jeopardy. If you come back at this point and say that the ROPS were approved, but a year from now or 18 months from now, they say, you know what, we changed our mind. That isn't approved. We're going to withhold your property tax and I thought I heard also sales, any of the funding that ultimately flows through Sacramento. If that's the case, then why even have a separate city? We become just as beholden as the schools or the community colleges for funding.
And the position is that some of those
Or the county.
draconian proposals are not only nonsensical, but they're unconstitutional.
They're illegal, yeah.
And they are illegal. That's correct.
Sure.
Well, this is good because I think we need to know what we are. And I'm still trying to identify myself with stripes or spots. And I don't yet know.
No spots.
We're going to start wearing the ties. Huh?
Stripes. When you talk about the may revise, the language, it is amending AB 26. This is language that was proposed by the DOF and has been accepted by the governor's office, or no?
No.
Just proposed by DOF. So there's this out there. There's competing language in AB 1585, Perez bill, and there's some other language in different legislation, proposed legislation, that covers these things. So there's a lot of competing language out there. When you talk about the may revise, you're talking about DOF's proposal. Is that a fair characterization? Is that
essentially? Legislative Council has cobbled this together. They've taken provisions from 1585 for purposes of the may revise discussion. The other bills that I just proposed, made the presentation to you on at our last Oversight Board meeting, are essentially all in suspense right now. And what this revision or this may revise reflects is a cobbling together of provisions from 1585 and from some of the other bills, including Pavley, which was SB 1335, that was concerning the Polanco Act. So it's a cobbling together of provisions that they think are going to address DOF concerns, address stated successor agency, some instances oversight board concerns of the League of California Cities, auditor controller offices, and others. It's a very fast-moving target. And so what we've seen along the way are these snapshots where we have the Perez bill, we've got other bills, 1585, the Dutton bill, which were attempts to address either comprehensively or in pieces such as Dutton with bond proceeds. And now you see the may revise trying to take a little bit from all of that and synthesize it into some language that they're trying to vote on. This wasn't unexpected. In fact, at some point in time, maybe about a month ago, there was discussion I heard through the League's legislative analyst's office that they were going to be sitting down, they meaning the legislature, was going to be sitting down to determine whether or not they could pull this together somehow. And I think, in fact, this is what that reflects, is the effort to pull the pieces of all that other proposed legislation together into one place. Whether or not it does successfully is yet to be seen. And if there are any further questions at this point, what I'd like to do is try and get us to the end of this so that you know sort of where we stand. And again, remembering that this is just a snapshot. This is proposed language, as Chair Raggio has indicated. And we will continue to update you as quickly as we can concerning how these changes would impact the Oversight Board's role with regard to overseeing successor agency duties to unwind redevelopment. So I'll just try and finish as quickly as I can, because it is somewhat laborious getting through this, and it is quite complex. So I think where we stopped is this provision where there's an effort to the auditor controller being authorized to deduct from property taxes that the taxing entities didn't get before. There are, as I indicated, problems with that. There's also a proposal that to give the auditor controller the authority to object to line items on the ROPS, and also would prevent the city and successor agency from re-entering into agreements with Oversight Board approval. That is a current provision within AB 26. And other significant miscellaneous changes include a change to the budgetary cap of 5%. That would apply for the first part of the year to only one half of the fiscal year. There was some confusion about that. It would allow for, it would redefine what the largest special district was. It would confirm that former redevelopment agency employees that serve on the Oversight Board would not have a 1090 conflict. And interestingly, it would appropriate $15 million to the Department of Finance to implement AB 26. So a little bit of power shift and money grab. Let's fast forward to where we are today in terms of these amendments. Some additional changes include, and I'm going to walk through them very quickly. Please feel free to stop me and we can talk about them if you have questions. Because we know that that litigation has been filed in Sacramento, and we expect not just the current litigation, temporary restraining orders and other things to prevent distribution of property tax funds to taxing entities where there are items in dispute, and to get declaratory relief as to what the intent of AB 26 is with regard to those disputed items, and how enforceable obligations are going to be honored by auditor controllers, for example, who have a fiduciary duty to the holders of those enforceable obligations. So in response to those larger concerns, current proposals are made to set up a special master in Sacramento Superior Court to handle and synthesize, again, I'm overusing that word, but really that's what it is, many of these lawsuits that are coming in, so that they can receive quick and consistent treatment. It would allow, in now addressing the ROPS, it would allow money to maintain existing assets of successor agencies to be placed on the ROPS as an enforceable obligation. It would also include as enforceable obligations the litigation costs of successor agencies to enforce the ROPS, to defend a litigation should the successor agency be sued. It would define project costs, would include the employees' time to implement projects. It would clarify that the repayment of CRAF, which is the Supplemental Education Revenue Augmentation Fund repayments, which are specified by statute, those would be defined enforceable obligations. It would allow for shovel-ready housing projects that were where agreements were entered into before June 28, 2011, to be completed, and that would mean to the extent additional contracts would need to be entered to complete those projects, those would be recognized enforceable obligations. It would include the repayment. Now, this is the best part. Getting back to what Ms. Babolian said and our concern about the cooperation agreements and the repayment of city loans to the city of loans made for legitimate redevelopment purposes, there is proposed language in this current version of the revised that would recognize that enforceable obligations would include repayment of those loans that were made for legitimate redevelopment purposes. We'll keep tracking that and we'll see where it goes, but certainly the issue is not dead. It is alive and well. It would define that a successor agency is, in fact, a body corporate and politic, a separate legal entity. Again, Polanco cleanup costs would be treated as enforceable obligations. One of the pieces of the May revise was the elimination of the housing authority. It would just be the transfer of the assets of the housing authority, but the revise intended to eliminate the transfer of all the rights, powers, duties, and functions of the housing authority. And so that created a limbo with respect to what housing authorities can or can't do, other than just babysitting their assets. And so the proposal is to restore that language, which was originally in AB 26. It refines that low and moderate income housing funds would be retained if they were unencumbered, to the extent any portion of that would need to be retained in order for the housing authority to perform its duties. It could be retained. It would also set forth that former redevelopment agency liabilities or omissions don't transfer to the successor housing authority to the extent that that the housing activities were undertaken by the redevelopment agency. If the redevelopment agency goofed up, that omission would not flow to the successor housing authority. It would eliminate the 60-day return of funds, which is that clawback provision from either public or private entities, as in violation of due process and violation of Article 13 of the Constitution. It sets up a meet and confer process over the ROPS, and that's one of the probably the most critical components that was missing from current version of AB 26. We've all been scrambling to figure out what administrative process we're dealing with, and there is no set forth administrative process. So efforts are underway to clarify that. It allows the ROPS to list obligations that may span over a 12-month period where there are principal and interest payments due. There's been pushback from the DOF that we are not supposed to list obligations that aren't within a particular 6-month period, but clearly we know that we have interest payments due and principal payments due at different times of the year. We were able to successfully convince the analysts at the DOF to allow us to retain line items on the ROPS where payment wasn't specifically due, but it would be within the next ROPS period. They agreed to allow us to do that. But we do know in other instances around the state, successor agencies were forced to remove those items for the ROPS. And of course, there's been significant concern, as we've seen in this response from the DOF, which states that they reserve their rights to disallow ROPS line items that were either listed or not listed on a former ROPS. So this is also a very important issue in terms of enforceable obligations and the uncertainty that it creates for bondholders and others. Just finishing up, it sets up several levels of meet and confer processes to remedy not just line items over ROPS, but also remedy payments to taxing entities, and that is the issue we were discussing with the non-payment that was made because of distributions that were held in 2011 and in early 2012. So there's a meet and confer process set up so that we can figure out how to make those payments. See if there's anything critical. And it does give some finality to decisions, here we go, of the Oversight Board in certain instances. This is still being played out, and we're hoping that it will include moving forward with respect to agreements that we might bring back for the implementation of projects that were identified with our bond documents, that the Oversight Board will be allowed to review those agreements for implementation of those projects, and the Oversight Board would have the final say whether or not that was in compliance with what was contemplated. So I think that there is some positive direction for successor agencies in that regard, both in terms of process and in terms of implementation of projects. Again, this is just proposed language. We don't know where we'll stand, but I am committed to, after today, I'm sure we'll have some additional information, and we can provide it to you again in as summary a form as possible in the next Oversight Board meeting, but certainly in written bullet point form on a going forward basis, and I'm available to answer any questions.
Doesn't that last comment of yours contradict this other one that says that the Oversight Board is obligated to DOF, but DOF is responsible for all final decisions?
This is proposed language to modify that provision that you mentioned.
And I would assume that once that language is finalized, there is no appeal?
Would not be an appeal, but potentially a lawsuit over the implementation, either as applied or on its face. There would be a determination of whether or not it's constitutional.
And who determines that?
A court. in that, as is atypical of this legislative review process. Normally, there is a longer period of time under which legislation is reviewed by the analysts. It's floated out to the stakeholders as well as analyzed by the Legislative Counsel's Office. So we're not sure to what extent the Legislative Counsel's Office has been in consultation and to what depth. So we certainly know that there are problems with AB 26. We don't know if to what extent we'll have similar problems here, but we're continuing to comb through this. Many people are continuing to comb through this to determine whether or not we do have ongoing due process, constitutional, or other problems, including impairment of contract or issues related to separation of powers.
Just real quickly, if I can ask a quick question on the proposal, the more favorable language that you identified, is that still allocating resources back to DOF to do all of this meet and confer, to do all these other processes? Because it sounds like we're spending a dime to figure out a way to divvy up a nickel.
About the distribution of funds for purposes of implementing that, I think the meet and confer process, it looks like the meet and confer process is on the successor agency to work with the DOF, and how the funding distribution for all of that occurs is still an open question. I think that's an important question, and one that I will pass back through the league this afternoon, because I did not see that particular question addressed, and this is still an open issue, and who pays for what and how it gets done with regard to administrative implementation is very important.
Further questions? Thank you.
Welcome.
We have an action item.
Yes, 4A is Director of Community Development regarding need for outside legal counsel for the Oversight Board. 4A1 is resolution directing successor agency staff concerning retention of legal counsel.
Good afternoon again, Oversight Board. I'll do the best to keep my voice. Getting a little gravelly here. The very short report, information has been provided to you. We received 9 responses to our request for qualifications, and a brief matrix of those responses has been provided in your packet, as well as the full responses themselves, which were PDF to you. I think in a couple of instances we provided the hard copies as well for your review. Essentially, we would like to give the Oversight Board the option of how it would feel most comfortable reviewing this process. Either make a decision based on the information that's been provided by the proposers, or direct the successor agency staff to gather more information. Within the limited amount of time that we have, we did not contact the references. We would be more than happy to contact those references and provide the feedback from those references to the Oversight Board. Or you could direct us to set up a closed session meeting, and you could meet with your top picks, with all of the picks. It's really at your pleasure, in that this is legal counsel for this board, and we're here to facilitate that process.
One question in that, in the matrix that you provided us, you've indicated numbers. I would assume those numbers are rated numbers? It's
a 1 to 10 scale, and again, it comes from the city attorney's office. Just look at relative level of it's an internal comparison, and some of the firms.
High is best, low is least. Okay.
Yes.
Yeah, or bowling. What's the pleasure of the board?
Now, would we be allowed to do a subcommittee, maybe to interview 3 of them?
Yes.
That answer was yes?
That's correct, yes.
Is that what you're proposing?
That's what I would propose.
And is there concurrence? All three. So your proposal is that we interview the three who are rated the highest here?
Yes, I would propose we take the 3 highest rated.
There are 2 8s. There are 3 8s. 1 9.
Mr. Chair, I would recommend that we not interview number 2, simply because the former city attorney
Is a part of it.
is a partner there, or is of counsel there.
The firm also currently represents the city in a litigation. So the city of Glendale is an existing client of the firm.
And for purposes of just streamlining the process, would it be possible, the top-ranked firm is the Green, Bortnowski, and Quintanilla. Would it be possible to either go with either Solon, Holtzman, Sakai, or Glassman, Colvin, so we're interviewing 2 as opposed to 3? Or is it the pleasure to bring all 3?
That's up to the board. What's the board's wish?
Well, my initial proposal was for a subcommittee to do it. And so,
Point well taken.
in that situation, I would just recommend all 3.
And the subcommittee would be made of a county pool?
Actually, for me, this is graduation season and very difficult timing
I
for me.
understand the reason for 3 now.
Yes.
But if we have 3 members of the Oversight Board, take a recommendation back and just go with those top 3?
Is that agreeable?
So is it the subcommittee will then interview 3 and then make a final recommendation back to the board?
That'd be my understanding.
I'm good with that.
Is that good with you,
I'm good with that, yes.
Ron?
I have a question, though. The report shows a $12,000 budget for next year. It doesn't look like we're going to get too far if we're talking travel and they're going to be attending all the meetings. I mean, it doesn't look like 12,000 is going to be enough. I mean, is 12,000 the limit that we're working within, or because it seems if that's the limit, it's got to be a local firm that we're going to have to look at.
Board Member Nakasone, at the time we plugged in the 12,000, it was just a placeholder. So once we get somebody on board and we negotiate a contract, we can come back and revise that number as needed.
So within the administrative budget, there's enough
Correct.
money to accommodate any of these firms?
And we, Board Member Nakasone, we also have a position that this isn't necessarily at solely administrative costs, that once it's a legitimate contract, once a retainer is entered, that we have an argument that should be placed on the ROPS.
If I could just confirm, after excluding law firm number 2, the top 3 are 4, 8, and 9. Is that correct?
The Rene Solon firm, the Green, Bertanowski, and Quintanilla firm, and the Alvarez, Glassman, and Coleman firm.
Oh,
That agreeable?
yeah. Now we just need 3 volunteers for the subcommittee.
Well, do we need a motion to do this? And maybe I'm asking out of order.
No, we can, I think your motion is composed of 3 members of the board to interview the 3 selected in that.
Correct.
And the only thing to complete that motion we need happens to be the names of the 3 members.
Okay.
Do we have volunteers?
Just one point of clarification. On Rene Solon, the San Francisco firm, the 285, assuming per hour,
Correct.
does that include travel? I mean, do they bill travel at their per hour? Do they bill travel at cost expense?
I will look at the proposal and confirm.
Who are the volunteers?
I'd like to nominate Phil Lanzafame.
I would very much like to accept. Thank you.
That's 1. Any other nominations?
Nominate Mr. Raggio.
I'll accept that. That's 2. Now we need it.
I would nominate Mr. Nakasone.
I was going to nominate you. How soon are we planning to do this? Before the next board meeting, or?
I think our next board meeting is next
Good.
Wednesday, isn't it?
Correct.
So it wouldn't be before then. I think you have to contact all three, schedule it, and this kind of thing. So it would be after that board meeting. Then our following board meeting is 1 month from then, is it not?
Correct, because the regularly scheduled meeting falls on the 4th of July holiday. So unless the board would like to have a special meeting in the month of July, which we can certainly try to accommodate, we won't meet until August.
You know, in fairness to Ron, I mean, you guys are going through quite a little bit right now, both end of the year plus transition, plus heavy time for you guys as well. If there's no objection from the board, because there's two people from the former redevelopment agency, I'd put myself into the mix to be the third member of the committee. Is that agreeable?
That's fine with me.
Yeah, that's fine.
Just to respond to Mr. Lansfame question, the travel-related expenses are not included in the hourly rate,
So they're on top of,
but that could be negotiated based on the Oversight Board's direction.
And we'll, with your motion now is complete, so I think the motion is to bring in the top three firms that we have there, and we can name them, as well as the three of us, the names here, to interview the law firms and make a recommendation to the Oversight Board. And we haven't given ourselves a time limit. So is there a maker, the maker and the second?
second.
All right. Any further discussion? If not, roll call, please.
Board members Zepkarian, Lanzafame,
Aye.
Nakasone,
Yes.
Ochoa,
Yes.
Sheehan,
Yes.
Eager,
Yes.
Caravaggio.
Yes. Motion complete. We now come to oral communications. I have one card. Aram Kasanchin.
Good afternoon, Honorable Mayor, I should say, Caravaggio,
Thank you.
and members of the Oversight Board. My name is Aram Kazazian. I am over here today to bring your attention on one thing. I know you're under a lot of pressure to get this project all done, but I caution you, please do your research, do your homework before you go much further. There are a few projects that I like to see the projects go. I'm not saying I don't want to see the projects go, but if those projects are going to be a white elephant of the city in the future, that's going to be a detriment to us. I'm sorry. That's my feeling on it. I'm an architect. I'm a graduate of Cal Poly San Luis Obispo. I practiced architecture for 37 years. If we build an apartment building that has 250 units and will only provide parking for the 200 units, the 50 units of it don't have any parking. Where are those people going to park? There was one project, I'm not naming any projects, 250 units. They do have tandem parking, but they only have 249 spaces free parking. And out of that, 50 spaces, after reading the plans yesterday, are for commercial use. The architect over here said it himself, those are for commercial use. Only 200 of them are allocated to apartment parking. That means 50 units will not have any parking. That's one. So I'm concerned about those kind of projects. And then we have another unit building, which is, I forgot the height of it, I think 16 stories something, which we have 173 units. Required parking on there is exactly 327 is the required parking. And we dropped down from 327 to 39. Even the staff report says 56, which is incorrect. It's only 39. They said, well, you can park in the aisles. The aisle parking will give you some more parking spaces. But it's a problem. That building is going to be detriment to the future. And they say, okay, 70 parking spaces we can rent from another parking structure for the lease of the term. The lease term is only between 5 to 7 years. After 5 to 7 years, the developer can purchase that land. If he purchases, he doesn't have to comply to rent the 70 spaces. So all of a sudden, the city is stuck with 39 spaces for 173 rooms. It's mind-boggling. And the same place, we have another building which has 46 apartment units with one parking each, 46 parking spaces, and has a commercial load on it of requiring another 200 spaces. And that is a zero parking. So where's all these people going to park? How much of it can the city parking structures absorb? Yes, they can rent it for a certain amount of lease, but after the lease expires, who's going to enforce that they have to come back and rent it? I cannot get hold of the redevelopment agreement with them to find out what those agreements are. So I caution you, please, before you go any further, see what's going on and take time and look at it, and because this is going to be a white elephant of our lifetime. If I'm not here, my children's going to be here. I lived in Glendale, since 1971. And it's really kind of a shame to see the city go downhill next 5 to 10 years from now, because we're going to be parking problems everywhere in the city. Thank you very much for your time. I appreciate it. I'll see you.
Thank you.
One quick question, sir. Ms. Van Meiden, is the role of this body to make land use policy and zoning policy?
No, it is not.
Thank you.
We have no other speakers, so I'll entertain any comments, sir? Board members?
Well, I was going to ask a question. Something Ms. Babolian said that I thought I might raise here. If we meet on June 6th, your statement was we won't meet again until August. There's a lot of business that has to happen in between then, so I would suggest that we look for a special date, either late in June or sometime after the holiday, July. And
Well, let's
keep a
make that.
meeting then.
Let's make that decision on the 3rd next week, and then, or pardon me, on the 6th, and then we'll come back with a date on that. I think we also have to come up with a schedule that relates in particular to our interviews.
Correct.
And I'd like to get that one in back of us as soon as we can. Any further comments?
I just want to remind the board members, if you have not yet submitted your Form 700, please do so. The deadline is next week. Thank you.
That's what I was going to mention as well. June 3rd is the deadline. Thank you, Elena.
Remind us who hasn't. I've forgotten whether I've turned mine in.
To be honest with you, I don't know who has. So, well, we have one. Actually, yes, we received it on the first day from Dr. Sheehan.
Okay, then
Exactly.
Then we're all due next week.
Yes, June 3rd.
All right.
And if anyone has any questions, they can call us down in the city clerk's office. We'll be happy to assist you.
Further comments? If not, I'll entertain a motion for adjournment.
So moved.
Second?
Second.
And we are adjourned.